my understanding of the functions of Parliament in lawmaking is in bills considered along the standing orders and passed in terms of Article 107 by the Constitution. So you have the laying of the bill, first reading, you have the consideration which deals with the principles, you have the clause-by-clause consideration of the bill in terms of amendments, and then when all that is done, the bill is passed by Parliament. Immediately the bill is passed by Parliament, Parliament is functus officio. You have passed the bill. It's left Parliament. You have passed it. That is why when you do the second reading and you do the clause-by-clause consideration, you require 24 hours unless the bill is of an urgent nature to do the third reading, so that you have opportunity to go over all that you have done to ensure that you don't pass the bill and bring it back for amendment. This is because immediately you pass the bill, the only option available to you now is amendment, because the bill has been passed. So we passed the amendment. The amendment was still in Parliament. It has not been assented to by the President. Then the Finance Minister was purporting to bring Agyapa Royalties. Agyapa, they have changed Asase Royalties to Agyapa Royalties.
So they were confirming your fears.
Well, they had confirmed our fears, but they were engaging in demonstrable illegality.
So the amendment was passed. But it was
not
law.
It has not yet been assented to.
So it was not law.
It was not law.
Oh, okay.
It was not law.
So no agreement can
no agreement can stand
on that
the amendment.
Okay.
Okay? No agreement can stand. Even as a Parliament, any agreement that is seeking to rely on the old law, on the law before amendment, cannot be allowed, because we in Parliament had changed the law.
Okay.
You understand?
Okay.
Because we did it, we are fixed with knowledge. So even if they were relying on the old law,
it still will not work.
It's not going to work.
Because that law is amended.
It's amended. And we know it's amended.
Okay.
Okay? And outsider can say, well, and then they will say, okay, because you are relying on the old law because the new law has not come into force yet.
Yeah.
But as Parliament, we cannot say that.
You cannot do that.
Because we amended the law, so we are fixed with knowledge. Actual knowledge, not constructive. Actual, because we did it.
You have passed the law. So unless the law is brought back to Parliament and say the President says, I will not.
Immediately we passed the law. If you read Article 106 carefully, 106.7 carefully, immediately we passed the law. It leaves Parliament on a journey to the presidency for assent.
Okay.
The president has a number of days within which to assent. If he has difficulties within those days, he has to inform the Council of State about those difficulties. And he returns the bill to Parliament for us to make those, incorporate his challenges. If not, within 7 days after forwarding it to the president, he has to sign it. And if he forwards it to us, if he has challenges and he forwards the bill back to us, and we resolve that the bill must be assented to in the way it is, the president has no option but to assent to the bill.
Okay.
Now, so Article 106.7 is actually the procedure that a bill comes into force. Now, so the law doesn't become a law until it is assented to.
Okay.
So you can't purport to be taking decisions on the amendment
when it has not been assented to. And as at the time these agreements were in Parliament, that amendment has not been assented.
They have not even left Parliament yet.
It was still in Parliament. So you had just it was the amendment was still in Parliament.
They have not even forwarded to the presidency for assent.
That's interesting.
That's why I walked out. That's why I walked out, because it was evidently, unconstitutional. evidently and manifestly unconstitutional. It was unlawful. I mean, the exercise we did was very unlawful.
But the speaker sat on this.
It was illegal in all its forms. What we did. And so I'm not even talking about the economic implications of what we did. I'm talking about the foundation. The foundation of the act. It's wrong. You can't. You can't. And when they moved the motion, I read the report. And even the report, they alluded to the amendment. In the report, page 4 of the report. They said the Mineral Act was amended. I said, yes, it was passed by Parliament, but not yet amended because it has not been assented to. So you can't purport to be taking a decision on a bill passed by Parliament but not yet assented to. You can't. And what's the jurisprudential position?
And you can't do it in expectation of the assent.
Parliament has no speculative jurisdiction. It has no speculative. You can't speculate that the president
will assent or not
assent.
assent.
You can't. We have no speculative jurisdiction. That's why when you are debating on the floor of the House, you can't speculate on issues. You must talk to the fact. The fact of the matter was that at the time that Agyapa was brought to Parliament, the amendment to the Minerals Income and Investment Fund Act had not been assented to by the President. In fact, I know as a matter of fact that it had not yet been transmitted to the presidency.
As at that time.
So on what basis were we doing that? On what basis? I just felt scandalized, and I use those words. I just felt scandalized. As a parliament, you see, parliament should be a bulwark against the abusive powers of the executive.
Okay.
Parliament must not be a willing conspirator in the abuse of office, of powers of the executive.
In this instance, that was what happened.
Well, that was what happened.
You helped. In fact, you assisted
for the executive to abuse his office.
Yeah.
And that was why I was virtually, I just threw tantrums. I said, you can't do this, Mr. President. I mean, Speaker, we can't do this. And I arrested the debate. When they moved the motion, and then it was not seconded. It was seconded at their side, and then the third person was contributing. I arrested the process. I got time and said I had a preliminary point. And the Speaker said, yes, what's the preliminary point? I said, Mr. Speaker, what we're doing is wrong. It's very wrong. We have no power to do what we are doing. And we're violating the provisions of Article 106.7 violently, because we have exercised our powers under Article 106.7 to pass the amendment. And so why were we doing what we're doing? He said, Inusah, what is the old law? What's the old law? I said, we're not dealing with the old law. We're dealing with a new amendment. I said, we're dealing with a new amendment. Then my colleagues realized that I was being emotional, and they told me that I should sit down. I said, I won't sit down. I'm going out. I can't be part of this. I can't be part of it. And I left. Now, so that's why I am not even prepared to go. You see, to begin to talk about whether Agyapa is beneficial, economical, prudent or not, is to understate the importance, the illegality. It's illegal in essence. It's illegal. And it can only happen under the Nana Akufo-Addo government. With a government that can behave with such levels of impunity. Because it's illegal. It's illegal. And I've said that the partners who are willing to and able to enter into relationship with Ghana through Agyapa Royalties should be very careful, because it's illegal. You can't build something on nothing and expect it to stand. It will fall.
So on the basis of this alone, the former president is right when he says that when I come, I will not.
There's nothing. There's no agreement because what is illegal is illegal is illegal. And then Lord Denny had said in one of those cases that is now locus classicus that you don't even need to go to court to declare it. Just refuse to accept it. Just refuse to accept it. It's illegal in essence. When I raised it and walked out, I understand that when they were making the resolution, they had to insert words like subject to ratification by the president, subject to assent by the president, because we were ratifying the agreement.
So Parliament assumed the speculative jurisdiction you said they did not have,
because they now came to their senses and realized that probably what we're saying was right, but obviously, because they were now a willing instrument in the hands of the majority was now a willing instrument, because we the minority, after I left, I understand all our members too left, but we the majority had now become a willing instrument in the hands of the executive. So what they did was simply to say that, well, this is subject to assent, subject to the amendment being assented to by the president. That was the resolution. I don't know what is the basis of that resolution and whether Parliament can pass such a speculative
legality of
that resolution.
Well, then how do you respond when the first deputy speaker, who was the one who oversaw those proceedings, then goes to speak to the media and then PP manifesto launch and said he does not understand the issues the minority had with the whole arrangement?
Oh, you wouldn't understand. Do you expect him to understand? In fact, I tell you as a matter of fact that if the first deputy speaker had said anything apart from what he said at the
manifesto
launch, that would have signified the end of the MPP. Privately, they confess. Privately, they tell us that, well, they don't know why we could not just wait few days for the president to assent so that we could bring this, because you are entered, because by Article 75 the president is entitled to enter into treaties, and those treaties can be ratified by Parliament. If the president decides that he's setting up Agyapa as an offshore company with others or under the Act, the Statute of Ghana, he can bring it for ratification, the agreement for ratification. So the agreement itself doesn't necessarily have to rely on the amended provision. Okay. But when you are bringing it to Parliament for ratification, the law should be there to support it. So you should have waited. You assent to the amendment, then you bring the agreement for ratification, and it would have been legal.
So having a